Welcome back, everyone. My name is Alan Ingleson, and it's my pleasure to moderate this final panel. We're going to start off by having our panel members consider 2 questions, and then if there are any burning questions from our audience, we will open up the session for questions from our audience, including those online. So the first question that I would like to pose to the panelists is, what are a couple of key messages that each of you would like to share with our audience concerning inspections and/or investigations? And I would like to start off with posing this question to Jennifer.
2 key things, okay. First, I think in the context of both, that I think clients and companies, whoever it is that's facing an inspection or investigation, have a tendency to go it alone at the beginning stages. So what I see as a lawyer is I'm brought in, or my colleagues are brought in, really quite far down the track. After employee interviews have already happened, they've been already audio recorded, and I find out about that. So when an inspector arrives at a site and is starting that compliance process, or you're into the investigation stage, wherever you are at, we always advise clients to at least go to their in-house counsel. Bring this to their attention. Don't go it alone. Make sure the company's aware of all facets of what's going on, and then if the external counsel needs to be brought in, they can be brought in. And then second thing, I think, is in the context of investigations and inspections, that I don't think you should be seeing the regulator as the enemy, and I have already said this early on in my talk. We should be collaborating. There should be a good, positive working relationship with the regulator. That's the point, and that's how you avoid a lot of these messes.
Thank you, Jennifer. Now let's turn to Heather in terms of the federal perspective.
Thanks very much. So first point for a takeaway is on outputs, counting outputs of inspections and investigations, and what that means. So as you may have gathered from my presentations from the past couple of days, we're trying to push some innovations in Environment and Climate Change Canada in the way that we do our work. What I'd like to see is that we get a lot better at targeting. We actually do fewer inspections, but those inspections bring back a higher rate of non-compliance because we've done the analysis up front. So we're doing a lot more focusing on where we think the greatest harms are. And I want to see us working on bigger files. Bigger files take a longer time, but they only count as one. There have been some fantastic files we've brought to court that have taken years and have had a great environmental outcome. If you're simply counting outputs, they count as one. So if we get to do all the great work I want us to do, what's going to happen is our inspection rates are going to go down. The numbers of the investigations we do might actually go down as well. But I think the overall environmental outcome will be much better. So for those of you out there measuring us, don't just count things. Look at what's behind that and see if there's actual value happening behind that, which is a lot harder to measure. It's harder for us to measure. It's harder for you to measure. But I think that's where the value really is. And I've mentioned Malcolm Sparrow a couple of times over the last 2 days. I'm going to plug him again. I don't get any money from his books, but he's had a huge influence on my career. So there's 2 books I'd recommend you read if you want to understand the type of work we're trying to do. The first is called The Regulatory Craft, and the second is called The Character of Harms. They're both by Malcolm Sparrow. So second point to bring across is if you are a regulated party or someone who represents a regulated party, read Jen's paper and behave accordingly. I think that people underestimate how much the behavior of a regulated party impacts how we end up dealing with them. If you lie and you hide and you obfuscate and you obstruct, you will find yourself in court. If you notify and you're responsible and you exercise due diligence in advance and after the fact, you do whatever you can to mitigate the situation, you're likely looking at a warning letter. The difference between being a good corporate citizen and a bad corporate citizen is something that we notice. And we're obviously going to try to reward good behavior and punish bad behavior. So I really appreciated your presentation this morning and would highly recommend that we all just do what she says.
Thank you very much, Heather. Jamie, in terms of the Ontario experience, investigations and inspections and/or 2 key parting notes, this is your opportunity.
Great. One thing we did not speak about is the province has been moving towards something called modernization of approvals. What is that? Well, it's modern, of course. Many agencies are now, they've been doing this actually for decades. It started in the U.S., God bless the U.S., called permit by rule. And what it means is, instead of you coming to the agency before you do something to get an authorization so the engineer can look at what you're going to do to see if it is all going to work out, you simply have to register the fact that you're going to be engaging in that regulated activity, and maybe you get a qualified person who is going to do X, Y, and Z. And so long as that qualified person is happy and everything else, and then you follow these rules, you can basically go ahead and do that activity. And therefore you're exempted from the requirement for an approval. And that's obviously basic environmental law. Environmental law started with the notion of doing licensing, requiring you to come and get permission first, because they wanted to make sure that they look at your engineering designs and they would say, oh yes, but you're basically going to discharge it in a pipe, that technology will work. We're not just going to give you the number, we're actually going to look at it before you do it. As we move into the brave new world of modernization of approvals, it does put more burden on the inspector, because the inspector is then going in and that particular activity has not been reviewed by the agency beforehand. So a whole bunch of things come up. First of all, we haven't talked a lot about what is a good inspection. In the Safe Drinking Water Act, it's interesting, we didn't talk about this, it is one of the few pieces of legislation, you'll be happy to know, that we follow the American example, where it actually tells you how often you have to actually inspect a facility by law. That is usually, have you heard, we have a lot of discretion up here. We just give it all to the government. There's not a lot of structured discretion. But what it means is that it tells you, number one, what is an inspection? And the actual officials who go in have to have as much expertise as the people that run the plants. They need to understand the plants. And I want to get there because many things are coming in. When you pass a regulation, when you pass a new program, that's not the end of it, and governments usually think it is. Are the inspectors trained? Do they have the expertise to go in and actually do whatever inspections needed in order to check compliance with these rules in a real way? So I go back to the permit by rule thing. We need to look at what happens to inspections when you have permit by rules, and what kind of burden's now going to be on the inspection, because they may be having to check a bit more than just basically looking at paperwork, et cetera, et cetera. So that's number one, is what is the impact of that? And my favorite thing, which I can't shut up about, and I'm sorry, is really trying to broaden the toolkit. I just think that we have to start looking at civil remedies, administrative remedies, because I find at the end of the inspection, it's a bizarre situation. You have an inspection report which may list 15, 20, 30 violations. You look at the facility and go, okay, well, what am I going to do? Refer those all to investigations and enforcement branch and we can have a prosecution about that? Yay for the lawyers. Sounds good to me. Or I guess I can give you a violation-based order to basically tell you to comply with something you're already required to comply with. In the U.S., my understanding is what happens is they look and go, well, we can all look at the administrative penalty regulation and kind of figure out what sort of penalties you're facing. And if you fix these things within a certain period of time, guess what? There may be reductions, meaning you're using your civil administrative penalties to send very strong signals about the sort of behavior that you want. And so I'm hoping that we basically move towards those tools, because I think for the inspectors on the front lines, it's important to maintain a good relationship. And the one thing I've heard a lot about from companies is they want to keep that relationship very close with the inspector. But we have to be concerned about regulatory capture, though, right? The inspector is not the friend of the facility. And I have to tell you, sometimes the facilities sort of refer to them in that way. I can work with them, they'll help me with a solution. No, they're the regulator. And that particular tool, I think, is important because it does say at the end of the day, this has to be fixed, it has to be fixed on time, and that penalty gives leverage in the compliance sort of negotiations. So we don't have to deal with it a year and a half later during the prosecutions, which goes back to investigations. I agree with Heather. Let's make prosecutions about the important cases. Bata shoes, that sent a huge message to boards of directors. There's another case called Aquatech Blue. Do you remember that one? That was, look it up. That was a case where a company was falsifying chemical documents for a long time, and it took a large part of investigation. You don't do that by just inspectors and that stuff. You do that by going back to the Intelligence Act, going in, finding out, what is the systemic problem here, and then seeing, what kind of behavior was going on that was passing under the radar the entire time. People falsifying manifests, etc. So it basically, going back to the investigations, is allowing the investigation and the prosecutions to be used for those types of cases that you want to highlight, that type of behavior is going to be found. Because I was talking about this with Owen before. I don't know, maybe the corporations in Canada are really honest. And maybe we don't have that kind of wrongdoing going on like you hear in your cases, the deliberate wrongdoing. Maybe that's the case. We're Canadians. We don't do that kind of stuff. I don't know. I think some of it may be going on. And I don't know if we're doing a great job in uncovering it, if it is. Anyhow, that's a lot of things. I'm sorry.
Thank you. John, in terms of the U.S. experience,
one thing I'd like to, before I actually mention the two that I had in mind, I want to mention, keying off what Jamie just said, that in my paper there's a footnote, I believe, to a reference about prosecutorial discretion and how in the U.S. the distinctions between the criminal sanction and the civil sanction and even the penalty assessment kind of minor civil sanction are not readily distinguishable when you look at the laws, because the same words are used to describe the conduct that could be enforced either criminally or civilly or through some other civil kind of minor civil enforcement measure. The footnote, as I said, is about prosecutorial discretion, but particularly what I wanted to point out to you all is that if this is a matter of interest to you, the author of this law review article, David Ullman, Uhlmann is his name, has written extensively about environmental enforcement history and practices in the United States, some of it very cutting edge. He has created a task force of his law students at the University of Michigan Law School to evaluate how what are all the circumstances that cause regulatory agencies and prosecutors to file criminal charges for particular kinds of conduct and not for others. And to key off on what Jamie was saying, he identified 4 areas that should be reserved for criminal enforcement as opposed to other kinds of conduct. And the 4 areas were where the violation results in actual and serious environmental and or public health harm. The second situation is where the actor, the violator, is operating outside of the regulatory system altogether, either in parts or in whole. A rogue operator, in other words. Someone who is constructing equipment which is going to create emissions without any permit or without even attempting to get a permit. Somebody who doesn't report at all. That kind of behavior. The third category is deceptive or unfair, intentionally deceptive or unfair behavior, or behavior which you would know is going to be regarded as deceptive because it is designed to fool regulators and to fool the public. So falsification of records, doctoring, monitoring reports, that kind of behavior. And then the fourth category is repetitive wrongdoing, where you're where it seems like you're clearly dealing with an actor that just can't get it right. And when it doesn't get it right, it messes up in a big way. And so Ullman's idea is other categories of wrongdoing should not be prosecuted criminally. And he also makes it clear there are plenty of opportunities for a robust criminal enforcement practice, limiting it to those 4 categories. So, having said that, the inspection advice I would give in terms of U.S. law, and this echoes one of the remarks that Jack Coop, I believe, made yesterday, have a list, a checklist, I believe is the term he used, at the facility that describes what your staff, facility staff, needs to do in both situations where inspectors come with a warrant or without a warrant. The warrantless inspections, the ones without a warrant, are obviously going to be much more common. But the behavior is going to be different, not in a lot of ways, but in ways which are very significant when you're dealing with a warrant inspection as opposed to an inspection without a warrant. People need to know how to behave. They need to know, and most of all, and you can do drills with staff. And in fact, I actually advise that your consulting company should be asked if they would be willing to stage a mock inspection with your staff. Sometimes you could even go to the other extreme and hire people that the staff has never even seen before and have them come and pretend to be regulators and really run your staff through the ringer and see what happens. And then you start to get a sense of how you need to control the reactions of your staff. What needs to be done when the inspection, on the inspection checklist, arguably one of the most important issues of all is you must know where in your files on the site that is being inspected are kept attorney-client privilege documents, any confidential business information documents, and if there is any trade secret information, where those documents are as well. Obviously, this needs to be done well before any inspection. They need to be segregated. They need to be marked clearly. In confidential business information situations in the U.S., every single page of a document that contains CBI must be marked individually as CBI, or it's not going to have a chance for you to defend that designation at a later date in court. You can't run the risk of a non-attorney making a decision, or there not being an attorney present to help make a decision, to get those documents first so they don't fall into the hands of the regulators without those designations being made, because if you waive the right to assert protection at the time the documents are seized, you may not have an opportunity to make that assertion later on. Afterwards, when the inspection's finished, I think the most important advice I could give is, and this is again the way that the U.S. system works, there is not the kind of distinction that Jamie and others were talking about yesterday between investigators and inspectors. It's not quite the kind of line that we have in the U.S. Inspectors can get data and immediately develop a criminal case out of it if it warrants that. The most important thing is there are opening conferences and closing conferences. EPA not only recommends this, but swears by it. They want, for their own benefit, to make sure that they communicate to the management of this facility what the scope of the investigation is going to be or inspection beforehand, what they're going to be looking for, and what kind of cooperation they want. That obviously helps the regulated entity prepare better for the actual conduct of the inspection. When it's over, the agency wants the facility to know what the problems were that were identified and what relative severity the inspecting agency assigns to those different problems. So the second piece of advice I would have is that when you come out of that closing conference, take very good notes and make a point of working with, if you have to report to officers, do that. Try to correct as many of those deficiencies that are identified in the closing conference as you possibly can, or be well on the way to doing so with a plan to finishing it before the agency issues its final inspection report, usually 2 to 3 weeks after the inspection. That way, you can immediately respond, as you're expected to do, to the agency with comments on their report, going on the record saying you've already corrected some of the things that were brought out, and here's what you're doing about the others, including changing your audit system if it turns out that's what you need to do.
Thank you, John. So the second question, looking to the future, looking ahead. For each of you, what types of issues do you anticipate that you'll be working on that will be emerging in the next 5 years? Let's start with Heather.
Thank you. So this is more of a personal reflection than official policy of Environment and Climate Change Canada. That's my proviso. So we enacted the Environmental Enforcement Act some time ago, and in it we have minimum penalties now that are meant to be high, and they're meant to be above the cost of doing business. So one of the things I had wondered about as that started to have an effect on our cases is previously I was seeing that a lot of our cases were settled out of court. because potentially the fine was cheaper to pay than the lawyer fee to fight it. And the reputational risk of going to court and losing was probably a factor as well. But now I'm anecdotally seeing, I don't have data on this yet, that more and more of our cases are going to court. And on the one hand, that excites me because when things settle out of court, we don't get a precedent and we don't get to test some things. And I like to push boundaries. I like to see where we can go and what the courts will say about it. But it also means that when things go to court, we're going to lose some. And we recently lost 3 cases in Atlantic Canada, one of which is being appealed by the Public Prosecution Service, one of which is not, and then the third we're waiting on a decision. And that's always the risk. So that's something that I'm watching very closely for the program that I run. And I take care of the headquarters program of enforcement. And so we're going to be looking very closely at those cases and what went wrong, what was good, what was bad, and to draw lessons from it. So that's something that I'm looking forward to with some excitement and some trepidation. But I think even the losses, I bet you they're going to be some of the best things that ever happened to us. Because we're going to take a lot from that and learn from it and get better. So on the one hand, I was a bit disappointed with the 3 judgments we got recently because I don't like to lose. But I think we're going to get a lot stronger out of it and come back fighting. So congratulations, Defense Counsel. But rest assured, we'll be studying that and learning and coming back a lot stronger next time.
All right, let's turn, just to shake this up. Jamie, what are you going to be doing the next 5 years, and what's going to be occupying your attention?
Exactly.
Retirement. No. I'm joking. Just a note of course, everything I'm saying is my views, not the views of the OPS. Sure, some of the things I've been saying, they're probably like, what? Especially, let's go to modernization of approvals. I do have to tell you, I mean, the whole goal of that modernization of approvals is to only allow for activities that have predictable environmental impacts. It is obviously not to take away the requirement for approvals for things that have unknown or significant impacts. But I go back again to think the move to a permit by rule system does have implications, I think, for inspections. Now let's go to your answer, to your question. You know, it's funny, we haven't talked a lot about a bill that was introduced on Wednesday, which is going to have big implications. It's something called cap and trade, or Captain Crunch. I'm just joking, cap and trade. So the cap and trade scheme that is coming to Ontario, I think, is going to be quite interesting because it is a whole different type of regime. It's not command and control. It really is using these economic instruments. And the ministry is the one who's going to be doing a lot of the compliance. So trying to develop the compliance and enforcement scheme for cap and trade, which, by the way, we're just following California. Thank you, and joining your market. You guys are always a leader. I think that is going to be an interesting experience as the cap and trade system, you know, gets rolled out. And I think it's going to be something we're going to be talking a lot about. It's interesting we had a panel on the contaminated sites today, because one thing we didn't talk a lot about is, and as these folks know, oh my God, naming officers and directors of corporations as responsible for contaminated sites. What are you doing, ministry? This is individual liability, and now these people have to pay $5 million. So I think there is a conversation that is going to have to go on about naming individuals and imposing individual liability. That we now do, and part of that is being pushed, which we haven't also talked about, by insolvency decisions, the Abitibi case. And it really was the Abitibi case that said, province, government, you don't have a claim, or if you do, getting back, because the banks and the other lenders are first. But if you have an order that names a whole bunch of people, well, maybe that's okay. So I think we have to talk about the implications of that particular decision and insolvency on how agencies are now trying to deal with these potential liabilities. When all of a sudden they get the call and they're told by the company, we're filing tomorrow, you know, you may want to show up. Oh, great, what do we do then? And then it really does move towards, you know, why can't we deal with this voluntarily? Well, when you're dealing with things voluntarily, I have to tell you, you have no standing whatsoever. If there's any measures taking place at that particular time and all of a sudden they go for filing, well, those measures stop. And if there's no order, you have absolutely no standing. So I think those are two big conversations that are going to be happening over the next few years. Not much to do, really, I guess, about investigations.
Thank you, Jamie. John, U.S.
And I am proud to be a Californian. Oftentimes much more proud to be a Californian than I am to be a citizen of the United States. But having said that, let me also give you another lawyer joke. There's a joke in the U.S. That lawyers exchange, at least, which is, how come New Jersey has all the landfills and California has all the lawyers? The answer is New Jersey had first choice. My first thought about what's coming up in the near future environmentally in the U.S. Are two items, one of which I think will be familiar to you, the other one of which maybe not, that are in the news a lot lately in the United States. The first of which is the control over hydraulic fracturing for natural gas extraction, popularly known obviously as fracking. The U.S. EPA is taking a very long time to develop draft regulations to regulate the construction, maintenance, security, et cetera, of closure, et cetera, of hydraulic fracturing wells. In the meantime, in the absence of federal law, there is an explosion of local ordinances, county ordinances in some cases, state laws in other cases, citizen initiatives in states that have constitutional provision for laws to be enacted by citizen initiative, all dealing with one aspect or another of hydraulic fracturing. Whether to ban it, whether to put controls on it, if so, what kinds of controls. This is clearly a situation that demands uniform federal regulation in the same way that most of the laws have already been passed, setting a floor below which no state can go, but above which, if a state wants to be tougher, it could go. I think that certainly within the next 2 to 3 years, there is going to be very, very serious federal regulations. I don't know what the statute would be pursuant to which the regulations would be promulgated. There has to be a statute that the regulations come out of. And it's impossible for me, I hate to say this validates the first remark I make, to imagine the U.S. Congress doing anything constructive in this way in the next several years. I'm not being facetious. However, to the extent that that doesn't happen and the regulations aren't promulgated by EPA in the next couple of years, there will be a patchwork quilt of state and local regulations that any company doing business in any jurisdiction is going to have to learn and start fresh with every time they step across a border of any political jurisdiction. Second one is related to that, and it happens to do with natural gas well construction and maintenance. In California, a week and a half ago, less than that actually, a 4-month-long leak of methane from a busted natural gas well in a field of 114 different natural gas wells in a very tony suburb of northern Los Angeles called Porter Ranch, was finally capped and sealed with concrete by the utility, which is the owner of that field of gas wells. Over 50 families had been evacuated and had been out of their homes for over 3 months. Mercaptan is the chemical that is added to natural gas to make it odorous, so that when there are leaks, they will be detected as quickly as possible in order to cap them, to stop them. No one, as it turns out, I didn't realize this, I've known about mercaptans for a long time, no one has ever done public health studies on long-term exposure to mercaptans. And that is in fact exactly what has happened to these residents in Porter Ranch, and the health effects are completely unknown. It also turns out there is no uniform regulation of construction, maintenance, closure, etc., financial responsibility requirements for natural gas wells. This field has 114. They're over 40 years old. None of them has backflow valves. States are now scrambling, as we speak, are scrambling to enact regulations to control methane releases from natural gas wells. again, and the EPA is also in the process of fast-tracking regulations. The last thing I want to say, though, is, and I'm going to sound like a doomsayer that I don't like to be perceived as, but I was telling somebody that when I give talks on the Russian environment, I start off with a doomsday statement and then come back from it. The doomsday statement is that the wisdom to recognize and halt follows the ability to pollute past rescue. I didn't know I was Oedipus until after I had fornicated my mother and killed my father. And my lesson, and in the Soviet experience, it's different from the US or the Canadian one, is that you can't embrace that attitude that you've passed the point of no return. Otherwise, there's no point in doing anything. You have to believe that there is always hope, that you can always make a difference, that you can always mitigate the damage that's out there, if not stop it altogether in some other way. The problem is climate change that is happening much and more rapidly. Florida is in fact flooding regularly. There are square blocks in Dade County, Florida, that are underwater virtually all the time. That's brand new. They can't pump it out. It's coming up through the geological formations that the city is built on. It's here. It's real. And as this gets more pervasive, without talking about what climate change mitigation needs to be, my concern is that the resources we now devote to Clean Water Act, Clean Air Act, hazardous waste management, wildlife, natural resources, are going to have to be reallocated. Those resources are not going to be available in the same ways, in the same volumes that they are now for the kinds of what we consider routine environmental enforcement and management and protection activities. You may have a lot of guests from the United States coming to Canada in the next few years, because not only do we have a very contentious political climate, but we have deniers of fact and science galore who seem only to be digging their heels in with more facts and science that is developed. So a cautionary note.
Thank you, John. Jennifer, as a practicing lawyer.
Okay, so I'm going to agree with Jamie that I think we're going to see a discussion that's going to need to happen on the naming of Ds and Os in orders. What we're seeing, and it's just even in the last couple months, as Defense Counsel and as Counsel to Companies appealing orders to the Environmental Review Tribunal in Ontario, it seems to be right of course now. Whenever an order comes our way or our client's way, Ds and Os are named, including General Counsel, in-house General Counsel being named on orders. Seen it a couple times. And that's just in the last couple months. Yeah.
We'll talk about this.
Yeah. So this discussion will need to be had. It's the primary concern, obviously, to companies, not just in the insolvency context, but outside of it. And this was not a company that is having any going control issues. Publicly listed company. Doing well, still had Ds and Os and General Counsel named. So it's a concern, and it's something that I think we'll be dealing with a lot more. And then I guess the other side of the fence for us is in the civil litigation realm with contaminated sites, we might see a good deal of action on Section 99 of the Environmental Protection Act, so the statutory spill action, which just recently with the Ontario Court of Appeal and the Midwest and Thornton decision gave a lot of teeth to. So yes, they did. So and not only the Ontario Court of Appeal recognized it's a no fault provision. It doesn't rely on negligence. You don't have to prove all the messy elements of the causes of action of nuisance and trespass. All you have to show is that the polluter was the owner of the pollutant that was spilled at the time of the first discharge, or is the owner of the property at the time of the first discharge, and you, neighboring property owner who was affected adversely. So it's going to be interesting. That might change a little bit of the landscape in terms of contaminated sites litigation. Query as to whether historical contamination can constitute a spill. That'll be a subject that will get a lot of play and I have a case dealing with that right now.
Thank you, Jennifer, and thank you to all of the
Thanks to Mr.
panelists in
Janet.
terms of these questions. Now, we'd like to open this up to questions from the audience. Any burning questions online here? Just a sec. Okay, the first question, and I will leave this open to any member of the panel to comment on. How do we ensure that evaluations of sectoral compliance take into account how the economy is changing, i.e., growth of the service sector, new industries, related green economy, the 3 Rs, energy cons? Who would like to respond? Jamie.
Is this on? Yeah, I think so. Just a quick rejoinder about the Court of Appeal case. And then we'll get to the answer.
Okay.
That really was a cause of action that's established by Part 10. The only thing the court was doing was recognizing what has not been used a lot, which is a cause of action, which is very significant. There's no doubt about it. That spills part passed by the minority government, not passed, but actually put in force by, remember, the good old NDP, Liberal. So that just gave effect to what was in the statute. I think the big thing was, and the Court of Appeal, without any sort of argument really on that, was said, oh, yes, officers and directors are part of owners of pollutant persons in control of pollutant, and just confirming what those decisions. Let's get back to your thing. For the sector thing, I think when you're looking at compliance, it goes back to the way you look at it. What this person, I think, is asking for is, when you're looking at compliance, if you're talking about the regulated firm, okay, well, that is the actual going to the firm and checking off they're meeting their requirements. When you're talking about a sectoral approach, that's different. And I think the regulator already does that. They understand when there is hardship taking place in a particular industry. They know, for instance, when the steel industry, the steel sector, whatever, et cetera, are basically meeting difficult things. And that comes through, and I'm sure it's the same with Environment Canada, and it basically affects the sort of type of response they have to that particular industry in that sector, about allowing them, if they need more time in order to come into compliance, or negotiating for the actual instrument that requires you, instead of giving you 3 months to do something, giving you 6 months. So I guess what I say about that is, there's definitely no doubt about it. Look, the regulator can't be blind to what is taking place in the economy. When it is difficult times, they understand that when they go in from that particular sector, and we know about this when you basically, in any sort of situation, that they basically have to approach that particular sector in a particular way. So I think that's already incorporated some of the decision, but I just want to make that distinction from that's a sectoral approach versus when you go into the actual firm, that's looking at the file, these are the requirements they have to meet, what are we finding? And that informs then the response once we found the violations, right, for that particular sector.
Thank you, Jamie. Heather, anything in terms of a sectoral approach versus anything to add to that, or would you?
Not in particular. I think you actually covered it all, except for the economic piece of it. I agree with you in part, but I think that needs to be built into the planning, particularly around natural resources extraction, that there will be a boom and a bust. We talked a little bit about that over the last couple of days. I'm not going to go further into it, but it is a reality. It is foreseeable. And I think firms need to act accordingly, knowing that there will be abandoned sites, there will be bankruptcies, there will be financial issues, and that's all foreseeable, in my opinion. And so while that is something that is taken into consideration, it's not a get-out-of-jail-free card because the economy is bad.
And I agree with you. Let's talk about that. I thought the mining example was really good. Mm-hmm. Why? Because when you look at the mining scheme, it actually recognizes that there's a state that you can be in when you have a very low amount of staff, etc. And that is true about many industrial associations. Things get mothballed. But just because an operation gets mothballed doesn't mean your environmental compliance requirements have to be, and that is foreseeable, and that's not what I'm getting at. But you're exactly right. And that's why I thought the fact situation was very good. Yes, there's only 3 people at the site, but you're still responsible, company, for those ponds that are going up, just as if you were in an active operation. So you've got to put measures in place, even though you've gone down to 3, to make sure you can meet that requirement, that those things don't spill. And if that means having 8 people on site, you got to have 8, whatever. And that's what I'm getting at. So there's no doubt about it that that's the beautiful thing about foreseeability. If these things are foreseeable, then you've had to plan accordingly. And I have to say, it's tough for business, right? Because why? To plan for those things means taking money out of the bottom line when you're working in areas that have really close margins and trying to explain that to shareholders, et cetera. I get that. But that's what the law tells you to do. You've got to plan. If you don't, that's when all of a sudden the officers and directors, et cetera, who are named on the order are wondering, why am I named on the order? Well, did you make the right decisions around the board of directors table? And that's why we have good lawyers like this to tell them to make sure they do.
Thank you, Jamie. Anything to add to that? Either John?
Just one quick thought, because as you're talking about mining issues in Canada, what I'm thinking about is and I think I talked to Jennifer about this in the break, the number of coal companies which are declaring bankruptcy in the United States or are in situations where the word about considering bankruptcy is getting out is increasing with a speed that I've never seen before. I'm not familiar. I don't do mining law. I haven't done mining law, so I'm not certain if there are any financial responsibility mechanisms in place with relatively new operating mines. But it occurs to me that where you know that a particular sector is financially stressed, where you can see across a spectrum of permittees or operators in a particular sector that they are all having some similar problems because of the economy. And you do some more due diligence, you call them in, you talk to them, you determine that they really are taking in water at a rate faster than they can get rid of it. Then I think it's time for I think it's imperative, frankly, that a regulatory agency look at its statutory authorities and determine when and at what point ought it to intercede and appoint a receiver or seek court approval to have a receiver or a trustee appointed to take the responsibility for prompt action and necessary action out of the hands of a business that is no longer able to discharge its responsibilities and threatens the environment as a result.
Thank you, John. Anything else?
I think everybody's covered it. I think one thing, and a colleague of mine, Dan Kirby, who's now retired from the firm he did, he would always say, why isn't, taking it outside of the sectors that have financial assurances, usually at the very beginning before they can get their approval to operate, like mining, why isn't this happening at the front end where, to get the approval and the permits, there's more of an FA required up front so that at the back end, when the crap hits the fan, there's money there.
I just want to let's comment, because I think it really is important with environmental law, right? Like, why isn't there that big pot of money to basically draw from? Let's talk about that. So, the application comes in, and let's say you have a really rigorous financial assurance guidelines that tells you how to calculate those liabilities, and the number comes out to be $25 million. You mean it's going to cost $25 million on top of everything to open up that plant? We need those jobs, et cetera, et cetera. So I guess what I'm saying is, well, you know what I'm saying. If we really are going to start seriously calculating these environmental liabilities on the front end, we better be ready for the real price, and that means that to open up that, oh, you mean this company can't open up the plant? No, they may not have the wherewithal because it's going to cost $25 million for a line of credit which gets taken away from their bottom line, and it's over at the province, and they can't get it back until they completely clean up, and then they can, and it's difficult to give that message to the politicians, et cetera, or whoever. And so I am all in favor, believe you and me, of getting boards of directors and everybody to basically calculate the environmental liabilities. The problems are, number one, trying to basically calculate them in an accurate way, and number two, really ready to stand by the number and say, it's $25 million, so if you can provide that check, you can get your environmental compliance approval.
Thank you, Jamie. Second, and this was a comment that I'd asked particularly Jamie and Jennifer to comment on. Permit by rule was first implemented for composting and waste transfer sites as part of Ontario's 3Rs regs promulgated in 1994. And the comment is this wasn't entirely successful because lawyers, presumably in Ontario, didn't understand it. Would you agree with that, Jamie?
I guess I need to understand, it's a good question. The 3Rs rules that came in, my understanding is really require these sort of recycling plants, et cetera, and that stuff at different commercial industrial facilities. The actual composting operation itself, where they emit odors and all that kind of thing, my understanding is those are still under Part 5 environmental compliance approvals. So, and I'd have to understand, I'm sorry, I do a lot more water than waste. But let's talk, okay, so let's say there are certain things. So I think the main operations that still cause impacts to neighbors, I think, are still under a Part 5, well, they now environmental compliance approvals, but it used to be Part 5 approvals. Jeremy, you can tell me if I'm wrong. But when it does come to permit by rule, and because the lawyers didn't understand, let's be fair, it's not just the lawyers that need to understand, it's the operators that need to understand the rules. The lawyers are just one thing. And we go back to the compliance promotion program that we were talking about. We're doing permit by rule now with a lot of these waste management programs that are coming out, like the pharmaceuticals and sharps I'm telling you about, where you're saying to the pharmaceutical companies, you have to develop these sort of programs. And so I think what always has to happen with these rules, going back to, is this: whenever you have a regulation, that's not the end of the story. The question is, what's your communications plan, as much as lawyers hate talk about that, in order to make sure that folks understand? And it's not just sending out a letter like the one we talked about, but it really is going to the facilities and sitting through, because those people are not going to read the regulation, but actually making, I hope they do, but you can tell me if they do. I don't know. Do they read the regulation? I guess you can tell me. But
Sometimes
not. But it's making sure they understand. And I have to say it's interesting, because as a government lawyer, you're often asked to comment on these guidelines that try and translate these requirements into understandable English. And as a lawyer, you're always very, oh my God, they can't rely on this, and you always have to put that caution on. You always have to go read the regulation. But as a practical matter, I understand why it is important to make sure that those rules can be translated. And number two, it really is important when coming up with the regime. It's amazing when you look at the rules. Sometimes they get so complicated, they do become difficult to comply with because there's so many compromises or whatever made. And at some point you have to look at a set of rules and go, okay, I mean, can are we making this too complicated? So, long answer.
Thank you. Jamie?
I don't have too much to add beyond Jamie, but Janet, if you have some in the waste, Janet being our Brownsfields expert or otherwise, but the only thing I have to say is Regulation 347.
Oh.
Can we please have some clarity on that?
Let's rewrite that thing.
So, I mean, if I look at it and it's Greek, people, it's the most convoluted waste regulation. We're all making our way through it, but that I can understand.
Let's talk about the best provision. It designates inert fill as a waste, and then it exempts inert fill as a waste. Janet, what does that mean? She has to write many memos on it and gets paid for it.
And what is inert fill?
All right. Well, at this stage, if there are no additional questions, I would like to take this opportunity to thank our panelists for their insights during the conference. And at this point, I'd like to make some concluding remarks. But thank you, panelists, for your contributions. Thank you. So to conclude in terms of this symposium on behalf of the Canadian Institute of Resources Law at the University of Calgary, first of all, I would like to thank Environment and Climate Change Canada for their support of this symposium. Without their support, quite frankly, this symposium would not have proceeded today. Secondly, to the Symposium Planning Committee, to all of the presenters at this symposium during the last 2 days, to the moderators, in particular Owen and Jamie and Heather, to the administrative assistants, Nancy and Sue, to the video technicians, and to all of the audience members that have posed thought-provoking questions. Truly, we would like to thank you for making this symposium a significant success. I hope that everyone has found this to be an informative and valuable learning conference. I would remind everyone that the papers, not only for this conference, but for the past 4 years are all on the Searle website under the tab Symposium, and I would encourage you to take a look at those. In addition, the next symposium will be held in Halifax. The tentative month for that is this coming October, and we hope that you will join us once again for the next Environment in the Courtroom. And at this stage, I would like to invite our hosts and partners from the University of Ottawa, specifically Heather, to make the final concluding comments. Heather.
Thank you so much, Alan. So I think thanks all around. I'm just not going to repeat what I'd planned to say. To thank Sue and Nancy, Alan and Owen for all of their help as well. Kenza, our assistant here at the center, was a big help to us as well, and for the tech support that was excellent. It's been an honor to have everybody here at our home at the University of Ottawa. I think the format of this session has been outstanding. I heard actually another participant yesterday saying that was one of her favorite parts of the back and forth between the various sort of stakeholder groups was really enriching and a lot of fun. And the questions and participation, both in person and online, have been great as well. So we thank Searle for their collaborative approach to all of this work, and we look forward to the next one in Halifax. Thank you so much on behalf of the University of Ottawa.